Number 2 be reported to the House by 11 March 2013.
The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. Call on Government Orders of the Day numbers 3 and 4.
Legislation Bill, Committee Stage continued. International Finance Agreements Amendment Bill, Committee Stage.
I declare the House in committee for further consideration of the Legislation Bill and consideration of the International Finance Agreements Amendment Bill. Mr. Chairman.
Mr. Speaker. Members, the House is in committee for further consideration of the Legislation Bill and consideration of the International Finance Agreements Amendments Bill. Members, we move first to the Legislation Bill, and we now come to Part 3. The question is that Part 3 stand part.
Mr. Chairman.
Charles Chevelle.
Thank you, Mr. Chairman. Mr. Chairman, Part 3 is an important part of the Legislation Bill. It does two things in substance. First of all, it replaces the current definition of regulations contained in the Regulations Disallowance Act with a new definition of disallowable instruments. It describes what such instruments are. It goes on to replicate in substance some of the provisions of the disallowance legislation, which are necessary for the operation of the Regulations Review Committee, and it determines the circumstances in which material may be incorporated by reference into delegated legislation. And I want to speak, sir, about each of those issues because they're each of them matters that have been considered on a number of different occasions by this House, but also often on reference from the Regulations Review Committee itself. So first of all, the issue of what will now be a disallowable instrument. The definition of the new type of instrument, for want of a better term, is set out in Clause 37 of the bill. Clause 38 also provides some elucidation on the term. And I know that when members look at the clauses, they'll think this is an odd way, perhaps, at first blush of going about the definition, because it's only going to be possible to determine whether or not an instrument falls into the category of a disallowable instrument through a relatively complex process of analysis. But this decision has been made deliberately, sir, as members who read the report of the committee will be able to see, and it's done in the interests of ensuring that the House is able to deal with the widest category of delegated legislation, something that isn't as satisfactorily able to be done as it might be in reliance only on the definitions that are contained in the current regulations disallowance legislation and in related acts. I think it will be very much a matter of having a look at how experience unfolds with the definitions that are set out in clauses 37, 38 and 39 before the House can determine whether or not this is the right approach. But it was the approach that commended itself on advice to the committee, and it is, I think, a worthwhile experiment to be getting on with. Sir, the next important parts of Part 3 are contained in clauses 40, 41, 42, and they deal with the procedure that is to be followed when disallowance of an instrument is to occur. Clause 40 sets out the general principle that the House is the master of delegated legislation, that any piece of legislation made under the authority of a statutory instrument or under the prerogative or any other type of subordinate legislation must always be subject to the ultimate control of the House. Having set out that principle, Clause 41 goes on to describe how disallowance should be able to occur. Basically, disallowance may be by motion, and then there are the particular provisions that set out the, in complement to the standing orders that govern the Regulations Review Committee's procedures, the provisions which provide for that committee's particular ability to exercise oversight of delegated legislation. And these, Mr. Chairman, are effectively a reenactment of the provisions of the Regulations Disallowance Act. The scheme will be well known to a number of members, but perhaps not to all members. And the effect of the standing orders and convention is this: if somebody makes a complaint to the Regulations Review Committee and the committee hears the complaint and a member of the committee determines that the complaint has substance, then that member is entitled to come to the House and put a resolution to disallow the particular instrument onto the order paper. The government of the day has 21 sitting days in which to bring on a debate about the disallowance motion. It must do that, and if it fails to bring on the debate, then the effect of that failure is that as it will now be, the disallowable instrument will lapse. And listeners might think, well, why does that matter? The only consequence of a disallowance motion is that after 21 days there has to be a debate. Well, the scheme of the Act, the current Act, which this bill continues and which the standing orders complement, is one of transparency. If there is, to use a colloquial expression, something fishy about a piece of delegated legislation, then a member who's heard the complaint about it can bring that piece of legislation to this House, and 2 hours, up to 2 hours of precious sitting time can be taken out of the legislative program in order for it to be debated. That is, if the government doesn't, as it so often does, simply agree to amend the offending piece of delegated legislation through a process of negotiation or agreement, which is, of course, the way that about 90% of the Regulations Review Committee's work is done. It's, I think, been a satisfactory means to exercise oversight of delegated legislation to date. This bill doesn't extend the mandate of the committee in any way, but it would be timely, I think, at some point for the House to consider whether overseas experiments with substantive review of legislation itself against particular principles of good lawmaking or particular pieces of legislation such as a Bill of Rights might be an appropriate role for a committee. But at the moment we aren't in that territory. It's simply a question of the legislation being reenacted so as to apply only to delegated legislation, or, as I've said, the new term will be disallowable instrument. The last point that I really want to make, sir, in this contribution relates to what subpart 2 will do over incorporation by reference in instruments. Now, it's been a concern of the Regulations Review Committee for some time that delegated legislation can make reference to extraneous material that isn't contained within the four corners of the instrument itself. For example, the material might be in a treaty or in rules made by an international body which New Zealand has agreed to cede some power to by becoming party to a treaty. Now, those rules might exist in some place outside New Zealand. They might exist on the internet. They might exist in some other place. And the issue of accessibility to the particular rules which are made the law of the land, but which don't appear in writing in any easily accessible spot, arises. And what the particular subpart in Part 3 of the legislation bill does, Mr. Chairman, is try to put some limits on the way in which delegated legislation will be able to incorporate such material by reference. I think the rules are sensible and they will improve the way in which such material does become part of the law of the land. The provisions that are proposed will certainly increase accessibility in ways that Mr. Chairman, the committee has previously recommended, and I certainly commend the subpart to the House.
Mr. Chairman.
Honourable Leanne Dalzell.
Mr. Chairman, thank you for the opportunity to